one of the things we see insurance companies do is they like to lump any kind of condition that's based on fatigue, exhaustion, cognitive impairments. They like to lump these all as just fatigue conditions. The insurance company are taking advantage of the inherently subjective nature of the condition. They're using contract limitations and other exclusion provisions in the insurance contracts to not pay benefits or limit paying benefits. And if you end up in litigation, you are going to be in great shape no matter what the standard of review is to challenge an insurance company.
Welcome, and thank you all for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker, Edward Dubdube. Edward Dubdube is the founder of Dubdube Law Firm, a law firm built for the sole purpose of helping people get their disability benefits from insurance companies. Eddie and the attorneys at the Dubdube Law Firm specialize in disability insurance law as well as life insurance, representing clients from across the country in ERISA disability insurance and individual disability insurance claims, appeals, and lawsuits. Eddie has successfully litigated some of the most unique and complex disability insurance cases. The webinar presentation that you're about to watch will be approximately 1 hour, and then Edward will be taking audience questions as soon as the presentation is complete. If you have any questions that pop up for him as you watch, please feel free to submit them through that Q&A button in the control panel at the bottom of your screen. Now, without further ado, here is Edward to discuss how to effectively handle long COVID disability insurance claims.
Good morning, everyone. Welcome. Thank you for that introduction, Nina. As Nina explained, we're going to be focusing this CLE on how to successfully handle long COVID disability insurance claims. And just want to say from the outset that we're focusing on insurance, not social security or other government benefits such as SSDI or VA benefits. So again, it's insurance claims with insurance companies, and specifically with a focus on ERISA, the Employee Retirement Income Security Act of 1974, which applies to the overwhelming majority of disability insurance claims nationwide. So with that background, I will move on to the next slide. And just to go over briefly what we're going to be covering, give an overview of the topic. We're going to begin with an explanation of what exactly is long COVID. We've been hearing a lot about it since the pandemic, but the CDC has a definition. Other reputable organizations have similar but varying definitions. So we'll discuss the CDC's definition, and then we'll look at what are some of the common symptoms, what are some of the unique problems these common symptoms present from a disability insurance claim perspective, what to do about that problem. And you know, those are some of the things. Like these symptoms are inherently subjective. They don't lend themselves very easily to traditional objective testing such as MRIs or X-rays, which disability insurance carriers like to focus on when making claims evaluations. And we will then move on to looking at just a few of the contract limitation provisions in long-term disability insurance policies. You know, what are the main provisions that insurance carriers are using to either deny benefits or as an exclusion, or to limit payments of benefits to either only 12 months maximum or 24 months maximum when you're dealing with medical conditions that arguably fall under the umbrella of fatigue or self-reported conditions. So we'll take a brief look at some of those contract limitations and then discuss how to get around that. Briefly, I'll talk about how ERISA takes already a pretty complicated case, claim and makes it more complicated. We'll look at some examples of denial rationales by insurance carriers, and then we'll dive right into how to make a long-term disability long COVID claim a winner, how to successfully challenge the insurance company, and how to get these claims approved without having to file a lawsuit, and if you have to end up litigating the case, how to make sure you have what we call a winner in federal courts, which is where you'd end up on these ERISA governed disability claims. And then we'll, time permitting, end with a brief look at some of the case law, and then I'll take some questions. So with that overview in mind, let's begin with a definition of what exactly is long COVID. And so the CDC's definition here on the side is some people who have been infected with the virus that causes COVID-19 can experience long-term effects from their infection, known as long COVID or post-COVID conditions. And so it is broadly defined as the signs, symptoms, and conditions that continue to develop after acute COVID-19 infection. And so here we have a list of some of the common symptoms. And I want to point out that as you hear stories from prospective clients, you'll hear different people have different symptoms. That's one of the unique attributes of long COVID. It affects different people differently, but we see some amount of commonality in the symptoms, and here are the main ones that we've listed. Now, you'll note that the overwhelming majority of these, except one, is inherently subjective. And that's the unique problem with a long COVID disability claim. You are presenting to the insurance carrier a disability claim, knowing that these symptoms are inherently subjective and difficult to objectively prove. So that presents some issues, right? So one of the things we see insurance companies do is they like to lump any kind of condition that's based on fatigue, exhaustion, cognitive impairments. They like to lump these all as just fatigue conditions. And as we'll talk about a little bit later on the next couple of slides, this ends up limiting benefits to maybe 12 months, 24 months, depending on the insurance policy provision. As I mentioned, ERISA makes this worse. We'll talk about the subjective symptoms and why those are hard to prove, what to do about it. And complicated medical condition is that most clients have a hard time getting to a treating physician that actually understands long COVID and not just can provide appropriate medical care, but can help during the claims review process. And then finally, we know that the insurance companies, by and large, their medical reviewers do not understand and certainly do not specialize in long COVID. And most of them are not in the business of treating patients to begin with, but instead are career medical reviewers for insurance companies. And so they may not either be up to date on the literature, and they certainly have no expertise by way of actually being hands-on in treating patients. And so there's a lot of misunderstanding coming from the insurance side. So here's a typical contract limitation I mentioned about chronic fatigue. This one deals with a specific list of conditions that are limited to 24 months. If we have 3 bullet points at the bottom of this slide: chronic fatigue syndrome, chronic fatigue immunodeficiency syndrome, Epstein-Barr syndrome, kind of all one of the same lumped together. Notice they all fall under chronic fatigue conditions. What we've seen sometimes is insurance companies try to rebrand long COVID as a chronic fatigue syndrome, right? Which is itself a distinctly different but very similar. In fact, to be truthful, it's hard to sometimes distinguish the two conditions. And there's a lot of research that's taking place in the medical field now that shows these are very closely related in some ways. And so insurance companies then like to take these long COVID medical conditions and kind of lump it under just generally a chronic fatigue type condition, thereby limiting payments to 24 months. Here's another one. These are the self-reported symptoms limitation. Many insurance policies have a Unum, I believe MetLife, Standard. A lot of these insurance policies will limit payment to 12 months, sometimes 24 months for medical conditions that are primarily based on self-reported symptoms. Notice the definition of self-reported symptoms. It is the manifestations of your condition which you tell your physician, right? That's self-reported, that are not verifiable using tests. Well, what types of tests and who gets to determine if those tests are objective evidence or not? They're not verifiable by procedures or clinical examinations findings. So, so someone cannot go into a physician's office and be examined and the physician says, yes, I noticed based upon this physical examination, you have a fatigue of 7 out of 10. You cannot be placed into an MRI or X-ray and you come back out and it says you have fatigue of 7 out of 10. You have all these other symptoms. You have cognitive impairment, etc., etc. So insurance companies like to take advantage of that scenario and say, well, there you go, self-reported, we're limiting payments if they don't outright deny it to begin with. So there are ways for us to combat these limitations and exclusions in the insurance policies. All right, what is ERISA? Just briefly, this is not a presentation on ERISA, but I believe the background is important. ERISA was passed in 1974 by Congress, and I think the intent was good. The intent was to encourage insurance companies to offer more insurance to the working class Americans through employers. So these are employer-sponsored health insurance, disability insurance, life insurance policies. Anyone who obtains any type of insurance through employment, that insurance policy and thus the claim would be governed by ERISA. What I've seen in my career, been practicing for almost 20 years, but certainly I'd say almost since ERISA was passed and certainly since a landmark decision in 1989 by the Supreme Court called Bruch versus Firestone, what we've seen is a body of federal common law that has developed in a way that is fairly hostile to plaintiffs or disability claimants specifically if it's governed by ERISA. And so what we're now up against is a situation where ERISA is unlike any other types of insurance claim. And here are just a few points, right? In a normal type of insurance case, you get to admit any evidence in a trial that is relevant to the question of whether your client meets the definition of disability in the insurance contract. Not necessarily so in an ERISA case. Most ERISA cases will be decided by cross motions for summary judgment. And we will have one of two standard of reviews that apply. You'll have a de novo standard, which is the court will just make its own finding based on the evidence. In most circuits, the court will still only be reviewing the documents and information in the insurance company's claim file. So there will rarely be any new evidence admitted to the court in litigation. And then you have what's known as an arbitrary and capricious standard of review. And this is where the court essentially tips the scales of justice in favor of the insurance company, affording the insurance company's decision to deny benefits, deny your client's appeal before the lawsuit was filed, unless you can establish that the decision was completely unreasonable. I've given below here an example from Unum, one of the insurance companies, what language is deemed sufficient to trigger discretionary review, to trigger that arbitrary and capricious standard. And if if you have a case that is an arbitrary and capricious standard of review, you'll definitely be working with a closed record. You'll be litigating it. You'll be limited in the amount of discovery you can obtain from the insurance carrier. Again, this depends on the circuit you're in, but generally, limited discovery, certainly no jury trials, and most cases decided on cross motions for summary judgment. And you have a heavy burden to carry. So I think insurance carriers in these ERISA governed claims know they have an upper hand, and if you combine this legal advantage with the inherent difficulties in proving up a long COVID disability, and you have a recipe for disaster for claimants, unless you have a certain strategy to counteract all these things. And that's one of the things that's actually the main thing we're discussing today. Before we get into how to prove up long COVID disability claims, how to get those approved, I want to talk about what some of the denial language, denial rationales look like. What are some of the things that insurance companies are saying? These are 4 excerpts that come directly from denial letters from our firm's clients. And you'll see variations of these, but by and large, they're all essentially saying the same thing, more or less. So number 1, insurance company says the documentation does not provide valid or reliable evidence to support impairment related to cognitive deficits. Well, what is valid? What is reliable evidence to support impairment? That's code by the insurance company to say, you didn't give us any MRIs. You didn't give us x-rays. You didn't give us, maybe blood work or some other laboratory testing that could objectively and validly show that there is impairment. They know those things don't exist. And so they know it would be unreasonable to come right out and say, but you didn't give us MRIs or x-rays. So they package it a little bit differently, but that's essentially what they're saying. Second sentence there is the MMSE, Mini Mental Status Exam, is a screening tool and does not address etiology. Okay, doesn't address etiology. That's true. Now, by etiology, what the insurance carrier is saying is, you haven't proven the cause of your client's impairment. That is a red herring. Don't go down that rabbit hole, because as I'll talk about a little bit later, and I'll show some case law, we are not required to prove the etiology. We're not required to prove the cause of our client's disability, of their medical condition. No, instead we have to be able to prove that there exists restrictions and limitations caused by symptoms that are severe enough that result in our client's inability to work on a reliable and consistent basis. Number 2 on this list, here's another one. The medical records currently do not support evidence of a positive test results. And while it is known that COVID-19 infection can result in long-standing chronic neurologic symptoms, the level of care does not support your symptoms to rise to the level of impairment, nor does it support that your symptoms are from a neurologic etiology. They're just throwing up all sorts of stuff there, but essentially, right, they're saying there's no positive test result. And then they end with, and we don't know there's a neurologic etiology. So essentially, they're now, again, calling into question, do you even have this condition? You haven't proven that you have this condition. And then there's a level of care does not support your symptoms rise to the level of impairment. What does that mean? Well, is your client going to a doctor every 6 months? Okay, the insurance carrier may have a point, not enough care. But be careful. Be careful to get into that game with them, because the reality is a lot of doctors, they don't really have a great way of treating this condition. So what does level of care mean when doctors themselves haven't really fully figured out how to treat someone who is suffering from long COVID symptoms? We'll talk about that a bit later. And then number 3, here's a language. Given lack of evidence to support your cognitive complaints, right? Lack of evidence. Well, how do you prove cognitive complaints? We'll talk about that shortly. But that's kind of falling into the typical rationales we see. It's a lack of evidence. It's not reliable evidence. It's not objectively verifiable evidence. Number 4, the reported symptoms, right? That terminology, reported symptoms, that connotes, it conjures up like this perception that it's only self-reports. You have nothing by way of examination or diagnostic findings to confirm these symptoms exist, much less that they exist to a level that causes one to be disabled. So those are some of the typical rationales that we're seeing from all insurance companies when it comes to long COVID claims. All right. What do we do about all of this, right? We spoke about the difficulty with these claims. They're inherently subjective. Treating physicians may not exactly know how to treat these conditions properly. Insurance companies, doctors certainly don't have the expertise to review these types of claims. And then the insurance company are taking advantage of the inherently subjective nature of the condition. They're using contract limitations and other exclusion provisions in the insurance contracts to not pay benefits or limit paying benefits, right? And then you get into court, you have ERISA where you're confined in what you can do from an evidentiary perspective. You're not allowed to introduce new evidence. You can't bring in witness testimony from your client's doctors, friends, and colleagues. You're very restricted, and you may be facing an uphill battle with an arbitrary and capricious standard where you have to convince the judge not only was the insurance company's decision completely wrong, but it was also completely unreasonable. Well, this is a strategy we have been using when a long COVID disability claim is denied. We follow this strategy to a T for the appeal process to the insurance company, right? One of the requirements of ERISA is that before you can file a lawsuit, you must go through this pre-lawsuit appeal process with the insurance company. And essentially, you're appealing back to the insurance company and saying, hey, please admit that you were wrong and please pay benefits or we'll have to file a lawsuit, right? And it's a bit tricky because the insurance company has to examine its own wrong behavior and correct that wrong behavior and acknowledge it was wrong and pay benefits. It's not going to, they typically don't do it on a whim. They have to be put in a position where they believe they do not have a chance of succeeding in court for them to first then say, okay, we will approve this appeal and avoid unnecessary litigation. Now, what I'd say is when we use this strategy, we don't keep metrics or internal statistics here at the firm, but the overwhelming majority of the firm's long COVID claims have gotten approved during the appeals process. I think we've had 1 or 2 that slipped into litigation and can't disclose the outcome of those litigations other than to say it was favorable for the client. And I think the insurance carrier's attorneys can recognize when you've created a file that's an absolute winner for the plaintiff, and they will adjust how they litigate that case. They would be hesitant to take that case to judgment. So let us look there at what are the things we do when we have to appeal. First, we have to build up our medical evidence, first and foremost. The majority of the long COVID claims the firm has handled, the client comes to us with somewhat weak medical evidence. There's not always a long enough history of treatment in place, and not always treating with the right doctors for long COVID. And so in many ways, you almost feel like you're starting from scratch. We have, over the last 3-4 years, we've been building up a network of doctors across the country, reaching out to some of the luminaries, the experts in the field of chronic fatigue syndrome and long COVID. And now we have a network across the country of physicians who can not only test our clients, they can perform independent medical examinations of our clients. They can write independent peer review reports that articulate exactly why or how our clients are unable to function on a reliable and consistent basis. And so we end up leveraging this network. And so let's just say we have a hypothetical client, let's just say Miss Brown. So Miss Brown comes to us. There's a dearth of medical evidence. She has long COVID. She may have been diagnosed with it, may not have been diagnosed with it. It really doesn't make a difference to us as to whether we accept that case or not, because we're not focusing on the etiology. We're not focusing on the cause. Instead, we're focusing on the symptoms and the restrictions and limitations resulting from those symptoms. And one of the first things we would do is we would gather all the medical records. And when we get all these medical records, we start already reaching out to the treating physicians to letting them know we're going to be sending Miss Brown to this sort of testing, and we will circle back to you. And the first test we send the client to is called a CPET. It's the first one on the bullet point. Cardiopulmonary exercise testing. We'll talk about it some more in case law below. But essentially, it is preferably a 2-day test that you send your client to that monitors the cardiopulmonary functioning upon exertion, physical exertion. How is the body responding to physical exertion? And without getting into the details and the science of it, it really is the best thing that we have right now. It doesn't measure fatigue per se, but it does support, I would say objectively, that if the client is suffering from debilitating fatigue, and that indeed is one of the hallmark symptoms of long COVID. And so we get this CPET report. And the CPET report ideally would say, yes, your client's unable to function on a reliable and sustained basis. Here are the reasons why. The report will also include data on how the client performed on the functional testing. Now, this is an important point because insurance carriers will challenge every report you get. So what we do is we take the CPET report and we send the report with the data to a second CPET expert who had nothing to do with the initial testing. We then ask this second expert, please take a look at this report and the data and tell us if it is accurate and reliable. And now, ideally, we get a report back from the second expert that validates the original CPET report. So now we have a CPET report and a validation of the CPET report from an independent expert. Next, most clients with long COVID also experience cognitive impairment. You cannot look at somebody and tell if they have cognitive impairments or not, unless it's extreme, right? But we're talking about your average case here. And so what we do is we send clients for neuropsychological evaluation. Okay, that is a battery of cognitive testing. It's done by a neuropsychologist, and it is a way of, as best as you can, objectively measuring cognitive impairments. And we would get a report from our neuropsychologist that walks through the different areas of cognitive testing, shows how the client is performing in the different areas. And this is an important point. You must have your neuropsychologist include validity testing in this report. And validity testing is a way of measuring your client's efforts to weed out things like exaggerating or faking on the test. Because if you don't have validity testing, you're opening up yourself to the insurance carrier throwing out your neuropsych report on the basis that it has no validity measures built in. No, you get back your neuropsychological evaluation report. It looks lovely. It says your client can't work. It goes into all the areas where your client is performing, underperforming. And like we did with the CPET, we now take the neuropsychological evaluation, the neuropsych report, and we send it off to a second independent neuropsychologist. And we also give that doctor the raw data from the neuropsych testing. And we ask the second independent neuropsychologist, doctor, please review this report, the findings, the conclusions, and please look at the data to support it. And write us a report to let us know if it is accurate and reliable. And in the ideal world, now we get back a second report that says, yes, I've reviewed everything. I've reviewed the data. It is reliable, and here is why. And now we have an explanation. So like we did with the CPET and the neuropsych report, we have propped up the reliability of these independent testing that provides objective evidence. It makes it now so much more difficult for the insurance carrier to dispute the findings. After we get the neuropsych report, the third thing, and I'm purposely going through here in order. The order of how you obtain testing and your evidence is crucial. You have to start with the CPET, get your neuropsych second, and third, send your client to an independent medical evaluation, an IME, not with any old doctor. Send your client to an IME with a physician that has expertise in long COVID. A lot of the physicians with expertise in long COVID are coming from a background of treating ME, CFS, chronic fatigue syndrome, and they've been doing that for many years. But there are certainly there are a handful of them out there across the country, and they're absolutely brilliant. They know this stuff inside out, and the insurance company has no one on the other side that is similar with training, education, and experience as the doctors we've been using. So now you have your client examined by a top long COVID physician, and that's where you send to your IME doctor all the medical evidence, medical records you've been gathering, the CPET report, the CPET validation report, the neuropsychological evaluation report, the neuropsych validation report. On top of that, the last bullet point, your IME doctor would also be getting letters and questionnaires that were completed by treating physicians, your client's treating physicians, letters that were completed by your client's spouse, your client's friends, or former co-workers of your clients who could attest to how your client was performing at work before falling ill, right? So that's a bit out of the non-medical evidence side, but you get all of this together. You send it to the IME doctor. You ask the IME doctor, please review everything. Please examine our client and prepare a report for us answering. You usually want 1 or 2 questions in there, depending on the insurance policy language. But the first question always is client X, is Miss Brown, able to perform the duties of her own occupation, as the case may be? Maybe you're in any occupation stage of a disability case, right? So her own or any occupation based on her training, education, experience. And we always qualify that question with on a reliable and consistent basis. Because the reality is, unless somebody's in a coma, most people can perform some work some of the time on an inconsistent basis. But that's not enough to not be disabled. So we want the doctors to answer the question from the perspective of client, can Miss Brown work on a consistent and reliable basis? Okay, and that's how we've litigated and argued the cases in court. Judges tend to agree. We get back our IME report. Hopefully it's brilliant. The doctor endorses the CPET findings, endorses the neuropsych evaluation. The doctor discusses her own history in speaking with Miss Brown, any examination findings that are possible. But now we get this IME report, and you think we're done? Not yet, right? We have one more report we want. When we're done getting all these reports back, we then take everything and we send it off for an independent medical peer review. This is a review of everything by a physician who has expertise in long COVID. And then we get a final report back, a peer review that answers the question about whether the client can work on a consistent and reliable basis. At this point, the evidence of disability is substantial, if not just overwhelming. And that's the idea. The idea by this point in your case, when you're appealing, is you do not want to have a close call with the insurance company. You do not want to have conflicting medical opinions, because if you do, you will lose that case in court 9 out of 10 times because of the standards of review. You want to polarize the evidence in a way where the insurance company looks at all this evidence and is faced with the reality that if it doesn't approve this appeal, it will litigate a losing case, because there is no way a judge would reasonably look at the quality and quantity of your medical evidence and non-medical evidence and instead defer to an insurance company's medical review by a physician who does not have the requisite training or experience to deal with a long COVID case. All right. So we focused on the medical side of the case, but one should never neglect the non-medical evidence side of the case, right? And so here are some of the things that we get from a non-medical perspective. I mentioned earlier, personal statements from clients, friends, former co-workers. I find those to be powerful. We've won cases in court where judges have cited to former co-workers letters or declarations. You can even get affidavits. Think about it for a second. If you are going into court with an affidavit that you got for the appeal process and sent to the insurance carrier before the lawsuit, that becomes unrebutted testimony, because the insurance company too cannot depose these co-workers. So now you've got unrebutted testimony. Take advantage of it. Get everybody to jump in on this. The client's spouse, family, friends, co-workers, have them all shouting from the rooftops exactly why or how this person is disabled. What are their first-hand observations? Second, we like to have clients keep a symptom diary. 2 weeks. 2 weeks, 3 weeks, every day. What are the symptoms you're experiencing throughout the day? And rank them from 1 to 10. And what you'll find is over 2-3 weeks, you end up having a powerful piece of evidence that gives the court a snapshot, an insight into what it is like to live in this person's shoes. Pictures are worth 1,000 words. Third bullet point, we love photos and videos of clients. We had a client, a young lady, who was on a remarkable career trajectory until she had long COVID. We ended up sending with her appeal several photographs of her in her wedding gown in a wheelchair. And one of the questions we posed in that appeal to the insurance company is, do you believe she has manufactured her disability claim by going as far as putting on a wedding dress, putting on a mock wedding, and going down the aisle in a wheelchair just so she could collect a portion of her previous income by getting a disability claim approved? There's no good answer to that for the insurance company, right? And so you can use that sort of evidence to polarize your case. It's either the insurance carrier has to accept all the medical evidence we just walked through, all those reports, then all this non-medical evidence, including your client, a photo of your client who is not going to be in good shape, and they have to accept all that as true, right? Meet me over here to agree she meets the definition of disability, or you've polarized them and pushed them way out into la-la land, where they have to take unreasonable positions. What we don't want to do is to leave them in the middle, where there is a debate, where there is reasonable conflicting opinions by doctors as to whether your client has sufficiently proven she's disabled. You don't want that. Lastly, a good thing to grab is if you get some employment records or emails. Sometimes what we've seen is clients have really, if they're working somewhere for a long time, they have accolades, recognitions, they have, great job emails coming in, they get sick. Then you see a change. You see emails coming in saying you haven't met this deadline, or what's going on here at work, or maybe they even have a poor review of performance at work. Don't be afraid to bring those into the foreground. Those things are helpful. All right, just really quickly, CPET. We discussed this earlier. It's tedious. We don't have the time to get into it, but what I want to point out is just briefly how we talk about CPET. Under the third bullet point, there's an excerpt from our appeal letter, right? We say the purpose of the CPET was to objectively assess her impairment. CPET testing uses objective measures. So terminology matters. How you portray this matters. Neuropsychological evaluation, right? Here's some excerpt from our appeal letters. We're talking about the findings from the neuropsychological evaluation. What we don't have here, though, is that I don't have to share with you, but it should be in our sample. We have a sample appeal letter showing how we put all of this evidence together. We would have another section where we speak about the expertise of each doctor who did the neuropsych, who did this, the person who administered the CPET. Then we'd also have another section talking about how each of these reports were independently validated by other physicians. Peer review. Let us see. Here is an excerpt from our appeal addressing the peer review report. Dr. X prepared a report after interviewing the client, reviewing her medical records, and independent reports of doctors Y and Z, the more doctors typically. As one of the luminaries in the field of immunology and chronic fatigue syndrome, Dr. X's report and conclusions should not be given significant weight. So what we're doing there is we're starting to now elevate our doctors, our independent doctors that we have brought into this case. We want to elevate them and hold them out as the experts that they are. Briefly, I want to just get into 2 or 3 cases, and then we'll stop to take some questions. There's a wonderful case that was handed down by the 11th Circuit in 2022, Sisson versus Unum. And one of the things that you see insurance carriers will try to do to your neuropsychological evaluation is they would take the whole report and toss it out. Because there are a lot of validity testing that's built into the report that I had discussed earlier. Let's say there are 3 separate validity testing and your client failed one. What insurance companies are going to do is discredit the entire report. Throw the whole thing out. Throw the baby out with the bathwater. But that's not okay. So what the CSUN court spoke to here is you can't throw the baby out with the bathwater because you didn't like one of the validity testing out of the 3 tests that were done. The court said, well, the other testing were reliable. So maybe one part of a neuropsych eval wasn't necessarily reliable, but the other parts are. And so the court faulted Unum for taking the whole thing and throwing it out. And so this is a good case for you to cite to argue that it's unreasonable to disregard the entire results of a neuropsych report because maybe 1 or 2 parts of it isn't perfect. And that's the whole idea, right? We are not required to present perfect evidence. We are required to provide sufficient proof of disability. So when you take your neuropsych, even if it's not perfect, and then you get it independently validated by another neuropsychologist, then you pair that up with the CSUN type argument, our court's going to rule in our favor on these issues. Abrams versus Unum, another Unum case. Interesting. Abrams was a trial attorney. He was making somewhere over $500,000 a year, working 12 hours a day. Then he got ill. Fevers, brain fog, weakness, fatigue, cognitive impairments. Those are some of the symptoms he was experiencing. Interestingly, and this is not unusual, Abrams saw 7 doctors. 3 said yes, he has long COVID. 4 said, we think it's chronic fatigue syndrome. Importantly, though, even though the 7 doctors couldn't all agree whether it was COVID, long COVID or chronic fatigue, they all agreed he was disabled. And that's what counts. Now, what happened in the case is after his appeal was denied, Unum argued he didn't meet the diagnostic criteria for CFS. And so what they're doing is they're attacking the diagnosis. And a lot of plaintiffs' attorneys make the mistake of going down that rabbit hole because it's a shiny object. Let me chase after it. Let me prove to you the diagnosis. Don't do that. Because the case law does not require, the insurance policy does not require, none of those 2 things require that you prove the etiology. You must prove symptoms that are causing restrictions and limitations rising to a level that your client cannot work on a consistent and reliable basis. The court didn't go down that rabbit hole. The court didn't fall for it. The court instead ruled in favor of Abrams, recognizing that he has brought forward sufficient proof of disability, even if they couldn't figure out exactly what was the cause. Last case, Vastag versus Prudential. I loved this case when it was handed down. Why? Because this is the first case where a federal court accepted CPET testing and said, not just, is it good? The court referred to it as the gold standard. And not just that it's the gold standard, but the court then said, this is objective medical evidence. So you can cite Vastag as the gold standard testing for CFS cases, long COVID cases, and then you can point out this is objective medical evidence. So now you're taking your long COVID case out of the realm of a subjective disability and you're thrusting it onto the insurance carrier with loads of medical evidence that is now objective medical evidence. The reality is that the insurance carriers cannot argue that you haven't met the burden of proving disability. One of the things we do after we submit our disability appeal is we start to then polarize the evidence, polarize our doctors against the insurance company's doctors, right? And we do these by sending very short, precise letters with a few questions to the insurance companies, questions that have no good answers for the insurance companies. And one of the questions we also like to ask is, let us know what, if any additional medical documentation or other information that you insurance company would like to see to finally approve benefits. And against the backdrop of having submitted overwhelming proof of disability and nothing else out there medically to give, they would never have a good answer for it. And I'll conclude by saying the majority of these appeals get approved. And if you end up in litigation, you are going to be in great shape no matter what the standard of review is to challenge an insurance company. With that, I will conclude and ready for questions.
Awesome. Thank you, Edward. Okay, we can now move on to the audience questions. So just a reminder, if you have a question for Edward, please feel free to place it in the Q&A button in the control panel at the bottom of your screen. It looks like we already have a few questions, so we can go ahead and dive right in. Our first question is just about it's FLCCC and its efforts. I'm not sure if you kind of know about that, but our person shared a link here about a network of doctors that are treating long COVID. If you had anything to add on that.
Yeah, I'm not familiar with it. Certainly I'd look into it, so I can't comment about it. The next question.
Yeah, the next question is long COVID covered as a pre-existing condition under disability insurances?
Yeah, I mean, all medical conditions are covered unless specifically excluded by the terms of the insurance contract. So the question of whether long COVID is excluded, it's the same answer as any other insurance. Any other medical condition. Yeah, that's a whole nother topic. But essentially, most insurance policies will exclude any medical condition for which you treated in the 3 months before you became enrolled in the disability insurance policy. So if you've treated within 3 months of becoming enrolled in the insurance policy, it will be a pre-existing condition unless you wait at least 12 months before submitting your disability claim, and then it comes out of being pre-existing. But this is contract language specific.
Got it. Thank you for that clarification. The next question we have is, what specific documentation and evidence is typically required? I know you spoke on what's been really successful for you, but are there anything that's kind of baseline required to support that disability insurance claim?
That's a moving target that the insurance company is going to give you, right? They're going to tell you they want to see maybe a blood work confirming that the person was infected with COVID to begin with. That's fine, you can give it, but that's really not even high on my priority list. I think there is no specific documentation. What you want to be able to do is to present as much medical and non-medical evidence as possible. And we did go through in the presentation some of the examples of what those could be.
Got it. Thank you. Our next question is, would you be willing to share a list of doctors qualified to perform the peer reviews and IMEs, or just a way to maybe find them in your area, if that's helpful?
Yeah, absolutely. So, I mean, that's something I think you should reach out to me directly on, and I'd make introductions.
Awesome. That sounds great. And then a next question we have is, in cases where disability insurance claims for long COVID are denied, what recourse options are available, and how do you handle that denial from a legal standpoint?
Well, if it's denied, you have a disability insurance policy that you got from work, then it's likely governed by ERISA, and you have to go through that pre-lawsuit process where you appeal the denial to the insurance company. If the appeal is denied, then you're marching on to federal court. I would stress here that nobody should handle these on their own. You really need an attorney with expertise in ERISA to handle these types of pre-lawsuit appeals. What you do on the appeal dictates the outcome, not just of the appeal, but if you're in court, the outcome of the court case. We say internally in our firm, we win our lawsuits when we lose our appeal. with the insurance company.
Great. The next question is, how should we navigate potential challenges like variations in symptoms or a lack of that standardized diagnostic criteria when you're advocating for your clients?
I think the varying symptoms is can be argued, yes, it's a challenge, but that challenge can be turned to an opportunity because the varying symptoms do kind of define the condition in a way. And I think that's when you bring in the experts here to look at, right? You should be documenting all of your clients' symptoms, right? And if you're documenting all these symptoms, and then you have an expert, a physician, looking at all of this, they can say, yeah, this is kind of the hallmark of long COVID. And what was that second part of that question, Nina?
Yeah, the second part of the question, let me pull it back up. Is how would you, for like advocating for your clients with that kind of variability in symptoms, how do you handle that and just in your advocacy?
Right. So we don't run from it. We use it. We take all of those symptoms and we point out that, again, this is a hallmark of the condition, but we validate these symptoms the best way that we can with objective testing. And there's a point where you've done so much testing, you've exhausted all the testing, you've spoken to all the right folks. There's nothing else possible that your client can do. And your client is therefore either a complete fake, and all the doctors you've consulted with have no clue what they're doing because they're supporting her, or she's actually disabled.
Yeah. And then our next question is, we have a lot of people, so in this lawyer's experience, they have a lot of people who have had the vaccine but still got COVID. He said he suspects some of them are vaccine injured, but medical providers usually shy away from that as etiology. Do you have any thoughts around that or any comments about maybe how to approach that if that's the case?
I don't know if we've handled a vaccine injury case. I've heard of it. I don't know. I'd have to think about it, and I think it depends on the specific case and the treatment the person is getting. But I also suspect that the same physicians we've spoken with and we've been relying on around the country that helps with long COVID, they're also probably expertise in the vaccine injuries or know people in that field as well. I think the idea is you have to consult with those experts and come up with a game plan to build up the evidence. Don't hyper focus on the source of the medical condition, be it a vaccine injury or an infection with COVID-19. Instead, focus on the symptoms and building up, validating those symptoms.
That makes a lot of sense. Our next question is, do you typically caution clients about what they share on social media related to their symptoms or their claims? What's your advice there?
Yeah, great question. So when a client calls us, I think that the general rule of thumb for us is just go quiet on social media. It's never a good idea because social media portrays your best day, right? For the most part. People usually post things on social media, whether it's Instagram or Facebook. That's not really a reflection of what's going on in their day-to-day lives. It's just a snapshot in time. And so we've had some cases where clients have put stuff on social media that makes them look like they're healthier, doing well when they're really not. We've litigated that issue in court. We've won that issue in court, but I'd rather not have that wrinkle. So just as a general rule of thumb, we suggest the client stop posting on social media.
Good advice. And then our next question is, can you elaborate on ways to establish eligibility for long COVID disability insurance claims, particularly in cases where the symptoms are maybe less visible or fluctuate?
I think that's the essence of the presentation, right? Everybody's symptoms fluctuate and are less visible. Less visible is just another way of saying inherently subjective. You can't see it. So it's all the testing that we have discussed. I think that's really the only way medically and legally to go about establishing disability. It really boils down to documenting. And this is a quick answer to a question, but I wanted to mention this. I know all of this is a high cost. Putting all of this appeal together, all this evidence, it's a high cost, but it's an even higher cost not to do it. It's a high cost to the client not to get paid.
Thank you for answering that second question. This is more of a personal question, but someone just asked, how did you get into long COVID claims and kind of handling those cases?
I've specialized in disability insurance claims since I was a law clerk at the University of Miami, and that's the only area I've practiced in. So I think long COVID claims, it's just something that as a law firm that has that focus on disability insurance, we get those type of calls, and we increasingly got calls. And as we came up with our strategy for long COVID cases, I guess word started to spread amongst the community of, well, this firm is successful in handling these types of cases a specific way. And it just has that kind of domino effect of people reaching out to us. And within our already specialty of disability insurance, we've, even specialized even a bit more in long COVID.
Awesome. I think that's all the questions that we have time for today. So thank you so much, Edward, for answering our questions, and thank you to you all for submitting them. We want to thank you all for joining us for another Justia webinar. As I mentioned at the top of the presentation, we wanted to remind you all of a great way to further enhance the Justia Lawyer Directory profiles that you all have, Justia Premium Placements. These placements through our Justia Lawyer Directory allow for you to be seen above the competition. I give you that extra edge, whether it's a fixed #1 placement with our Justia Platinum placements or ranking highly above the organic directory listings with gold placements. We're here to help you get in front of people who are looking for a lawyer now. So if you'd like to learn more about that, you can go to marketing.justia.com. Thank you again, Edward, for your time, and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.